Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, in this video, we would like to study what is Vakalatnama, what is the importance of Vakalatnama, how to file the Vakalatnama, how to fill the Vakalatnama, when it is to be presented by the court, and how does it impact the interest of the client when he filed the Vakalatnama before the court. Vakalatnama is a written document that is given by a client to an advocate to appear or to plead on his behalf before the court. This is also known as memo of appearance and Vakalat Patra. Friends, Vakalatnama is nowhere defined in the Code of Civil Procedure and the Power of Attorneys Act. Friends, the meaning of Vakalatnama is defined in the Advocates Welfare Funds Act 2001 under section 2U, which says Vakalatnama includes a memorandum of appearance or any other document by which an advocate is empowered to appear or plead before any court, tribunal or other authority. What does it mean? That Vakalatnama should be a written document. It authorized by the client to his advocate to appear and plead before a court of law or any tribunal. Now, we would like to study what is the provisions of Vakalatnama provided under the Code of Civil Procedure. Friends, Order 3 Rule 4 of the C.P.C is very important. We would like to study and I would like to read Order 3 Rule 4 of the Code of Civil Procedure. No pleader shall act for any person in the court unless he has been appointed for the purpose by such person by a document in writing, signed by such person or by his authorized agent or by some other person duly authorized by or under a power of attorney to make such appointment. What does it mean? It means that no person, no advocate can appear before the court on behalf of any party except senior advocates to appear and to plead unless a written document has been signed by the client in his favor. Through the written document only, he can appear and he can plead the case of the client before the court and tribunal. Subsection 2 says, every such appointment shall be deemed to be in force until determined with the leave of the court by a writing signed by the client or his pleader, or until the client or the pleader die, or until all proceeding in the suit are ended so far as regard the clients. Three aspects are important. Vakalatnama came into force when it is determined by the court with the leave of the court, number one. Number two, when it remain in force up to the lifetime of the client, and when it ends, when the client die or the advocate die, or it is withdrawn by advocate or client. Now question arises how to fill the form of Vakalatnama. So it's very relevant. So client should know that how to fill the form of Vakalatnama. So first we have to mention the name of the court. Then we have to mention the case number and case type, like SB civil writ petition number such and such, like that. Then we have to mention the name of the parties. Then we have to mention the name and complete address of the party who is signing the Vakalatnama in favor of his advocate. Then the terms and conditions has also be read by the client as well as by the advocate. Then the fees and payment schedule, which is very important, which is usually written in the Vakalatnama, that on such and such fees the client engage the advocate to appear and plead before the court and authority of the advocate. Now the question arises that is very important with respect to the clients, that what precautions should a client do before signing the Vakalatnama. Client should read all the terms and conditions. Client should make payment of fees as mentioned in the Vakalatnama. Client should understand that the advocate has a right not to appear before the court unless he has been paid the entire fees. And client should also important that after signing the Vakalatnama, whatever pleading or whatever document in writing or whatever statement given by the advocate on behalf of the client shall be binding upon the client. It is very important aspect. Once you sign the Vakalatnama, once you authorize the advocate or pleader, then all statements given by the pleader on your behalf, whether in writing or verbal, shall be binding upon the client. Now, question arises, when Vakalatnama came into force. Vakalatnama came into force when it is duly signed by the client, when it is accepted by the advocate and duly signed, and when it is submitted before the court in a case. Another question arises, who is authorized to give Vakalatnama? This is very important aspect, and very carefully the client has to examine that who is authorized. The aggrieved person who wants to file a case and he is competent to make a contract is authorized to sign the Vakalatnama. In case of a company, the person who is authorized through a board resolution is authorized to sign the Vakalatnama. In case of a firm, partnership firm, in case of the proprietorship, the proprietor is authorized to sign the Vakalatnama. In case of the partnership firm, any partner or manager authorized on behalf of the partner through a power of attorney is authorized to sign the Vakalatnama. Or any person who is a authorized person having a power of attorney of his client is authorized to sign the Vakalatnama on behalf of the client. Now the question arises, up to when the Vakalatnama is valid or remain in force? The Vakalatnama is valid and remain in force till the end of the case. Supposingly, a civil suit is being filed, so up to the end of the case, up to the judgment, final judgment and decree, the Vakalatnama remain in force. Up to the lifetime of the client, the Vakalatnama is remain in force unless that has been withdrawn. Up to the life of the advocate, the Vakalatnama remains in force unless it has been withdrawn. Or in case the client engage any other pleader and obtain no objection certificate, then up to the date of NOC, the Vakalatnama remain in force. Now we would like to study two very important judgments which has been delivered by Honorable, one is by Honorable Allahabad High Court and other is by Honorable Apex Court. The title is, citation is Bairu Singh versus Babu Ram. It is reported in AIR 1997 Allahabad, page number 185. What has been held by the Allahabad High Court? Very important observation I would like to read. Vakalatnama is not required for legal work such as giving opinion, sending notices, drafting petition or other documents, but signed Vakalatnama is required to be obtained when it is filed in law courts or tribunal to enable the lawyer to plead case on behalf of clients. Many times he approaches the client, the advocate, to give the legal opinion. So Vakalatnama is not required. Vakalatnama only required when you engage an advocate or a pleader to appear on your behalf before a court of law or a tribunal. That is the verdict of the Allahabad High Court. Now, one important judgment citation delivered by the Honorable Supreme Court is Uday Shankar versus Ram Kalevar Prasad Singh. It is reported AIR 2006 Supreme Court 269. The Supreme Court held that Vakalatnama, a special power of attorney, is an important document which are binding on the litigant who is the principal. It is a document that creates a special relationship between the lawyer and the client. If once an advocate is appointed, then his all statements is binding upon the client. So this is a very important citation of the Honorable Supreme Court. So this is all about Vakalatnama. Hope you like my videos, and if you like my videos, kindly do like and subscribe. Thank you so much, friends.